This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why arbitration may be used to resolve claims of fraud and why in New Jersey an arbitrator must decide no-fault fraud claims. This case is about the relationship between New Jersey healthcare providers and the insurance companies that pay those providers for treating patients for injuries arising from automobile accidents. In GEICO Inc. versus Careon Pain Management, PC, aka Careon Pain Management, Jinghui Xie, MD, First Care Chiropractic Center, L.L.C, and Konstantine Fotiou, D.C., a May 31, 2023 decision of the United States District Court for the District of New Jersey. The insurer attempted to defeat fraudulent claims under the New Jersey no-fault law. Multiple GEICO insurers, known as the plaintiffs in this case, alleged a series of fraudulent schemes, including unlawful compensation in exchange for patient referrals, misrepresentation of the nature, extent, and results of patient examinations, and false representations regarding compliance with pertinent healthcare laws. In deciding a motion to dismiss brought by the healthcare providers, pursuant to Federal Rule of Civil Procedure 12b-6, a district court is required to accept as true all factual allegations in the complaint and draw all inferences from the facts alleged in the light most favorable to the non-moving party. The Insurance Fraud Prevention Act, the IFPA, which was enacted roughly a decade after the no-fault law, provides that an insurance company damaged as the result of a violation of any provision of this act may sue therefor in any court of competent jurisdiction. In part, the New Jersey legislature enacted the IFPA to address rising insurance rates resulting from widespread fraud, with the clear objective to confront aggressively the problem of insurance fraud in New Jersey by facilitating the detection of insurance fraud and eliminating the occurrence of such fraud through the development of fraud prevention programs. A person or practitioner violates the IFPA by presenting or preparing false or misleading statements in connection with an insurance claim, or by failing to disclose the occurrence of an event that affects the individual's entitlement to insurance benefits or the amount of benefits. The no-fault law's language, legislative intent, and application cover the plaintiff's claims for common law fraud, unjust enrichment, and RICO. The plain language of the no-fault statute provides that any dispute regarding the recovery of benefits provided under personal injury protection coverage arising out of the operation, ownership, maintenance, or use of an automobile may be submitted to dispute resolution on the initiative of any party to the dispute. The plaintiff's claims involve 1. A dispute by the plaintiffs, 2. Involving defendant's recovery of PIP benefits that one party wishes to send to arbitration. Consequently, plaintiffs' common law fraud, unjust enrichment, and RICO claims fall within the statute's arbitration provision. Having reviewed the no-fault law's language, legislative intent, application, and arbitrable claims with plaintiffs' claims for common law fraud, RICO, and unjust enrichment, the United States District Court found there was nothing preventing an arbitrator from hearing the claims. The plain meaning of the New Jersey Insurance Frauds Prevention Act, the IFPA, requires insurers for damages under the IFPA be judicially resolved. Although the statute states that insurers may sue in any court of competent jurisdiction, arbitration does not constitute a court of competent jurisdiction. Yet, to the extent the IFPA may seem to contradict the no-fault law, state legislatures are presumed to be aware of prior enactments, including the pre-existing no-fault law. The state legislature could have provided a carve-out for PIP benefits dispute in the IFPA, but did not. The United States District Court concluded, therefore, that to avoid duplicative findings, the court in its discretion declined to separately entertain the IFPA claim under the Declaratory Judgment Act. To the extent plaintiffs seek a declaration that the defendants violated RICO, committed common law fraud, or are liable for unjust enrichment, an arbitrator shall, in the words of the court, decide the issue. In my opinion, clearly the healthcare providers who were accused by GEICO of fraud felt that they had a better chance of success with an arbitrator rather than a federal judge. The judge found the statutes allowed for arbitration and sent the fraud to an arbitrator. I would like to be that arbitrator and hope the plaintiffs get an arbitrator who dislikes insurance fraud as much as I do and find they would have done better with a federal judge. GEICO should be honored regardless for working to defeat fraud by attempting to take the profit out of the crime. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll be advised of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,550 blog postings. You can also subscribe free to the videos on rumble.com or youtube.com, and I'd appreciate it if you do, that you click on the like button or on the thumbs up button on rumble.com. I would also appreciate it if you tell your friends and colleagues about the blog and the videos and let them subscribe if they so desire. And if you wish further detail about insurance law, insurance fraud, and insurance claims, please consider for a small fee subscribing to my Substack publications or my locals community. Thank you for your attention.